So evidence in your settlement agreement or exit package negotiation, what is the point of it? And, having established that you do actually need it, then how do you go about getting that? And also, what are the pitfalls to look out for in terms of the game of snakes and ladders that sometimes negotiating settlements agreements does actually feel a bit like? So firstly, why should you get evidence? Well, actually, it's not always a straightforward case of you tell your employer what happened and they believe you. And even if they do believe you, it's not always a straightforward case of them admitting what they've done to you. So you might even have to show them that you can prove it in court. Now, we don't want you to go to court or to go to employment tribunal because that's a long drawn out process. Don't get me wrong, we've done that. I personally have done that, a large number of times, stood up and done all the talking in court, and we've all been able to do that in the past. But right now, we're much more bigger fans of just negotiating settlements out of court. It's a lot quicker, it's a lot easier. There are tax breaks involved. It's basically everyone's a winner. So there's a lot of incentives for you. Perhaps you're wanting to leave your job, your employer wants you to leave. What a great time to negotiate a settlement. Well, the more evidence you can bring into this picture, the stronger you can build up the kind of round overview of your case, the more your employer is likely to take you seriously and frankly to be a bit worried about the chance that you might sue them. So they're going to give you a better deal, a better settlement agreement negotiation. So you do need evidence. How to set that evidence out? Try setting it out in writing. That would be the best advice. Obviously, if you have got a lawyer, they'll know exactly what to do. For example, we are pretty much experts in this exact field. But if you're going to try and do it yourself, try and use numbered paragraphs. Try and stick to dates, times, places, who said what, when. And then, in terms of media, emails, WhatsApps, texts, letters, perhaps even witnesses, these things are all fair game. Witnesses, a bit difficult. You might think your colleagues are going to be kind of queuing up to stand up for you. They might be your mates. But when it comes to the crunch, you're kind of asking them to put themselves in a difficult position because that might affect their kind of career progression, I was going to say, but it might affect their career progression. So, certainly letters, emails, these things are indisputable. There they are in writing. They can't be denied that was said. So other than that, maybe the old-fashioned way, just taking a diary, keeping a little kind of a set of events that happen to you in chronological order. Audio recordings of meetings, they could be a little bit borderline in terms of what's acceptable and what isn't. You're still trying to maintain this trust between you and your employer, even though that trust may have completely broken down because of the course of events that's transpired, and that's obviously why you're leaving. At the same time, no one wants to feel like they're being taped. On the other hand, if you have got a particularly overbearing or even aggressive manager, these things happen a lot. It might be that an audio recording is the only way. If someone's literally shouting at you and bullying you, perhaps their boss or HR don't believe that's going to happen. Perhaps in that scenario, you might be justified in taking a recording. I would advise you to read a lot more about that specific point and other points about evidence within all the articles on the site here. And then just a couple of pitfalls to look out for. Your employer can monitor your communications, so it can work both ways. They can read your emails. So even emails sent on your private accounts or Skype and so on, if it's using the work computer, that can be accessed. Now, when you're collating data, which by that I mean collecting your evidence, be careful how you do that. If you're going to put it on a memory stick or even print it out, or emailing it to yourself is the worst one. They can find out that you're doing that, and you can be disciplined for that or even dismissed. And try not to take any confidential information in terms of client lists or prices. Even if you are trying to demonstrate some kind of elaborate fraud, try and steer clear of that particular pitfall, because that really can be used against you. And then other than that, the final point to note, subject access requests. These are great things which entitle you to request all the information your employer holds on you. Okay, and you can request that. They have to provide that within 40 days. You have to pay a £10 fee, send it off. We've got some templates here on the site, so use one of them. And that's really great, especially where perhaps you've got a board, a small to medium company. The board of managers might have actual WhatsApp groups, where they're discussing you and trying to get rid of you, or other internal communications. They don't want you to see that, because that would enable you to kind of prove to a judge that you're being set up for a big fall here. So you're being engineered, your dismissal is being engineered, you're being managed out. No one's saying you should go to a judge and prove that, but certainly if you can prove something to a judge, then you can use that in a negotiation and effectively win a negotiation, which by that, when I say win, I mean, get yourself a fair deal, a decent settlement agreement, exit package. So evidence, probably number one thing to go about collecting when you're trying to reach a negotiated settlement. Thanks a lot.